Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. So today the topic for discussion would be on reservation in super specialty courses. So basically whether there should be reservation in any of the super specialty courses, research courses, or is it only the merit that should alone be the benchmark? Now the Honorable Supreme Court back in the year 99 had held in the judgment of Dr. Preeti Srivastav and others was the state of Madhya Pradesh that merit and merit alone should be and is the basis for admission at any super specialty level. So to elaborate further, we have with us a very special counsel. He joins us from Jaipur. We have with us Mr. Kushagra Sharma, who will be amicus for today's session. Now, just to give you all a brief introduction about our amicus for today's session, Mr. Kushagra Sharma, he co-founded the law firm KP and Associates in the year 2015 with the vision of setting up a multi-service law firm in the state of Rajasthan. He has advised the government of Rajasthan in matters pertaining to establishment of Madrasa Board and was instrumental in drafting the Madrasa Board Act of 2020, which has been passed by the Legislative Assembly of the state of Rajasthan in the year 2020. He has drafted the rules for Rajasthan Board of Muslim Waqf, which has helped the Waqf Board to function more effectively. Apart from government institutions, he has also advised various corporate houses on diverse legal and commercial issues, such as advice on building bylaws, CSR, exit policies, business development, etc. Now, Mr. Kushagra Sharma has also represented various individuals and entities, both in civil and criminal trials. He's also represented doctors before the Honorable Supreme Court of India, wherein a challenge was laid to a state policy, vide which reservation was being granted to a class of candidates for the purpose of securing admission in NEET super specialty courses. So thank you so much, Mr. Kushagra Sharma, for taking out time on a working day, on a Monday afternoon. And the stage is set, the floor is all yours, over to you.
So thank you, Jay. It's a privilege to be part of the amicus, virtual amicus rather. So the topic for the day is whether there should be reservation in super specialty courses or not. Well, it is a very volatile topic, so to say. Volatile as in various government have fallen when they talk about reservation, but today we are just dealing with a small aspect that whether there should be reservation with respect to admission in super specialty courses. Now, India, as we all know, is a diverse society, and a diverse society has both pros and cons. Discrimination was one of the cons, and that is the reason the constitution framers, they thought it fit to have Article 15 and 16 of the constitution, which grants them, the state, the power to have reservation. So reservation per se is for upliftment of the backward, the minorities and other socially and educationally backward class of people. But here we are dealing with just a small aspect of reservation, that is whether there should be reservation in super specialty courses or not. In the year 1979, a committee by the name of Socially and Educationally Backward Committee was set up, which we know as the Mandal Commission. So the recommendation of Mandal Commission was finalized in the year 1983 and it was implemented in the year 1989. By the year 1990, the VP Singh government, it implemented the recommendation of the Mandal Commission by government orders. By the September of 1990, a writ petition came to be filed before the Honorable Supreme Court of India by Indra Sahani, and the Honorable Supreme Court granted a stay on the particular government order which sought to implement the Mandal Commission. So now, subsequently in the year 1992, the Honorable Supreme Court upheld the government order, and thereafter, by specifically directing certain criteria, that is up to 50% should be the benchmark or the upper limit of grant of reservation. Now, in super specialty courses, what does Indra Sahani say? Because Indra Sahani specifically says that yes, there should be reservation because as there was discrimination, or to give a level playing field to everyone, there should be reservation. 50% should be the upper limit, but there are certain class of people which rather not just the class of people, there should be a group of people who deserves the proper treatment, equal treatment. But in super specialty, merit and merit alone shall be the criteria. As in, they say that medical courses wherein super specialty doctors are there, research and analysis where super specialty and technical skills are required and training is required, there merit and merit alone shall be the criteria. I hope I'm audible and you are able to hear me.
Absolutely,
Jay.
Mr. Kushagra Sharma. Absolutely. Please proceed.
So Indira Sahni was in the year 1992. Thereafter, various myriad judgment of the Honorable Supreme Court specifically and categorically held, and till today it is being held that yes, there should be reservation, but there should not be a reservation with regard to super specialty courses. The reason being that the super specialty course, they require special training, they require special hardships, so to say, they require special talent. And once everyone is equal, that is at the time of basic admission or so to say specialty admissions, once everyone is deemed to be equal, if after that point of time, if we give reservation to any person, it will amount to be treating equals as unequals, which specifically was the concept of reservation. Not to everyone is equal in India, and hence that particular concept was brought in while the Supreme Court held that there shall not be any reservation pertaining to super specialty courses. Now, there you must be aware about Schedule 7 rather, entry 66 and that is the union list, and the concurrent list entry 25. So they both talk about how the union and the state can basically coordinate and determine the standards of education, be it technical or medical, any field. Now, what the state government in India are trying to do is they are trying to encroach upon the particular right of union government, wherein it is only the union government which can coordinate and determine the standards of education. So what happened was the state government started giving reservation to a particular set of people, a class of people, group of people, wherein they started giving incentives and reservation to people who were in service of the government. And the idea behind giving that reservation was that they thought it fit that people working with the government should be better. They are in better shape and they know the environment better as compared to a person who is not in the service of the government. Now, the issue arises that when in a super specialty course, I'm dealing with the medical super specialty as of now. So dealing with the medical super specialty, there are a very limited number, rather there are a handful of seats which are earmarked for super specialty courses in India. Now, one state, let me name it, it was Karnataka and Kerala. They started giving 60% reservation to students, rather doctors who were in service of the government, which clearly sidelined the merit. Now, there were a few number of seats for super specialty in states of Karnataka and Kerala. So if you grant 60% of the seats, I think nothing more remains for, because more the reservation, less is the chance for a meritorious candidate to succeed there. So Supreme Court in the judgment of Faculty of AIIMS versus State of New Delhi stated that the concept of reservation itself brings mediocrity. So taking a cue from that, it is a fact that yes, super specialty courses, they require special talent, special skill, a little more hard work as compared to any other vertical, as to say. So Supreme Court in the Faculty of AIIMS specifically stated, taking a cue from the Indira Sahni case, that no, there shall be no reservation pertaining to any admission in super specialty courses. Now, Dr. Preeti Srivastava, as Jay already mentioned, Preeti Srivastava versus State of MP, it was again held by a constitution bench of this the Honorable Apex Court that yes, there should be reservation, but there cannot be any reservation with regard to admissions in super specialty courses. And the idea, the logic behind it was that as super specialty courses require special knowledge, talent, and skills, so it should not be open for everyone. Rather, it should be open for everyone, not just a handful of people. And merit alone should be the criteria. Secondly, Preeti Srivastav says that once there is a equal playing field, level playing field for everyone, once everyone is equal, everyone is uplifted, there is no point in giving additional advantage to equals. It will amount to making equals unequals again. Hence, it was said to be completely opposite the spirit of the Constitution of India. Now, I hope I am making sense to you, Jay.
Yes, absolutely.
So, Jay, Indra Sahani, Preeti Srivastav, S. Sadashiv Rao. These were the cases which dealt with the fact that, yes, there cannot be no reservation. The state does not have any power to grant reservation pertaining to medical examination, medical admissions. In 2018, there was a judgment passed by Honorable Justice, as he then was, Arun Mishra, in the Tamil Nadu Medical Officers Association case. So that case was decided in the year 2020, wherein it was held that yes, states are empowered to grant reservation. State can have a separate channel of admissions. So this particular case has brought in itself, and rather it has brought in sea change in the admission process. Why? Because it says that states can have reservations, states can have a separate channel of admissions in postgraduate courses. So now, in 2020, I happened to appear before the Honorable Supreme Court in a matter wherein state of Karnataka and Kerala brought in a government order wherein they granted 60% of reservation to in-service candidates, claiming that yes, they say that their government order was backed by the Tamil Nadu Medical Officers Association case. As per their understanding of that particular order, they thought that yes, even in super speciality, there can be reservation per se. We challenged that particular order. We filed a writ petition against that particular order in the Honorable Apex Court, with the sole, not the sole, rather it was the primal argument that since time immemorial reservation is there. So reservation, the concept of reservation is as old as India. In the year 1950, with the Republic, the concept of reservation came in. But there has to be a fine balance between merit and upliftment. So super speciality, what does super speciality? As we have already discussed, it requires special talent, skill, hard work, which was appreciated in earlier judgments of the Honorable Apex Court, being it Indra Sahani, being it Gujarat University's case in the year 1987, being it Preeti Srivastav. So all these judgments specifically said that yes, reservation should be there, but not at the cost of merit. At super specialty level, there cannot be any reservation because it will be against the interest of public at large, because the concept of reservation itself, these are not my word. The Supreme Court said that the concept of reservation itself brings in the meaning of mediocrity. So we filed a writ petition before the Honorable Apex Court. Apex Court, while granting us an interim order, stated that yes, there cannot be, for this particular purpose, that is for the academic year 2021, there cannot be reservation, and the counseling and the admission should be strictly on the basis of merit. So the idea behind that particular interim order was what flows from Indra Sahani. So Indra Sahani, Preeti Srivastav, Gujarat University faculty of AIMS, S. Sadashiv Rao. All these judgments particularly deal with the fact that there shall be no reservation, particularly in the super specialty courses. Article 15 and 16 were obviously dealt with by the Honorable Supreme Court. Entry 66 list 1, entry 25 list 3 were also dealt with, which say the state can have the power to coordinate in the educational matters, technical matters. So my idea is, as super specialty deals with specific vertical, specific knowledge, specific training, specific and much more hard work as compared to any other admission or any other vertical, so to say. Supreme Court is right in saying that there should be no reservation in super specialty courses, because it will be detrimental to the interest of public and interest of India. Why? Because merit and merit alone should be the criteria at such scales of admissions. So Jay, I hope, what is your view about reservation in super specialty courses?
I personally feel that the judgment that is delivered by the Honorable Supreme Court of India should be applicable to all the super specialty courses, and merit alone should be the sole criteria. But I just wanted to ask you one thing, Mr. Kushagra Sharma. What was going through as a personal experience when you contested this matter before the highest court in the country? What was going through your mind? Because reservation in India obviously is a very sensitive issue, and it is one issue that would attract volatile, diverse opinions whatsoever. Because there people bring in the argument of the financial background, the backward statuses. So what propelled you to make your submissions? Is it the research that you had, you had done, or?
It was the research. So my firm has been dealing with the cases of doctors from the year 2016. So we know the hard work they put in, we know the work they do. So if at the end of the day, if everything is taken away from that just by a stroke of a signature by some government employee stating that reservation should be there and they should not be permitted, or they are excluded from admissions in super specialty courses, this is what prompted me basically. So in this particular case, what happened was, thankfully, we had one of the best, in my opinion, one of the best benches. It was Honorable Justice L. Nageshwar Rao, Hemant Gupta, and Justice Ajay Rastogi, which Honorable Justice Rastogi elevated from Rajasthan only. So we made a particular point, pertinent point, and to the point that the fact that the law is settled with respect to super specialty courses, that there shall be no reservation. There cannot be admission. A generation of doctors, engineers, and other technical people cannot be, a generation cannot be wiped off, basically, to say the cream cannot be wiped off just on the account of some government order. Indira Sahni lays the law precisely saying that, yes, there should be reservation, but there are certain fields wherein there should not be reservation. Super specialty courses, research courses, PhD courses, there should not be reservation, because it brings in mediocrity. This is what Honorable Supreme Court said. These are not my words. I know it is a very volatile topic. Governments come and go on this particular point only. Mandal Commission. So what prompted Indira Sahni was the Mandal Commission. So it was in force since 1979 and it implemented in 1989. So it took 10 years for a government to implement what Mandal Commission said. So it is indeed a volatile topic. And being lawyers, it is a privilege to be on both part of the dais rather. So I have represented cases wherein, yes, reservation is required, but not at the level of super specialty. This is what my case is, that there should not be any reservation in super specialty cases. This is what has been held since 1987 by the Honorable Supreme Court.
So you basically dealt with reservation with respect to super specialty courses in the medical field. Any other field, if you could draw some light, or you think that requires consideration where the honorable courts should intervene or fix those gaps or loopholes?
So what has happened since 1987, there is no reservation per se in super specialty courses. There is no reservation in super specialty courses. So till the level of super specialty, there is reservation, and we know why reservation is essential for the growth of and the concept of India. It is required. But now, due to petty politics or whatever the behind the curtains deals is happening, they are trying to dilute what the Honorable Supreme Court is saying and has been saying since the year 1987. So this is what, so there is a lot of politics going on in the down south, which pertains to the regionalism, which we can say, the person who are ordinarily citizen of domicile of that particular area and who are outsiders, so to say. There is a lot of politics going on. Hence, this particular government order was brought in, which stated that only the rather 60% of people working with the government domicile in that particular area shall be giving a reservation, wherein there are around 500 seats of in super specialty, and out of that, Kerala and Karnataka have most number of seats. If they eat the cake completely, there will be nothing left for the meritorious students. And we are still thankful to the Honorable Apex Court that they granted us a stay, because merit is the need of the hour, and there should be a fine balance between merit and reservation. It cannot be a one-sided road. That is what I think. But the other part of your question, wherein you ask what are the other verticals where reservation is there, there are none. Just the constitutional reservation is there, even in UPSC and other public service commission examinations and admissions. None in super specialty. This was the one of the unique cases where I was privileged to be a part of, and hopefully we'll get a favorable judgment in our favor that yes, there shall be no reservation in super specialty courses. But yeah, India is a diverse nation, idiosyncrasies are there. This is, I think it will go on and on and on. But this issue needs to be settled down. It is too volatile to be kept alive.
Couldn't have agreed more with you, Mr. Kushagra Sharma. So thank you so much. Well, we all are aware that doctors and medical practitioners have proved to be frontline warriors. They're the heroes. And Mr. Kushagra, as you mentioned, that he has fought and contested so many battles and so many, he's done a lot of litigation on their behalf. So we hope that in future you continue to do the same, to fight for the right causes for our heroes. And so this session was absolutely brilliant. And I hope and I presume that it will immensely benefit all our viewers who are watching on reservation in super specialty courses. Now, our email is mentioned on the channel. In case of any query, feel free to write to us. We'll be more than happy to forward the same to our amicus for today's session, Mr. Kushagra Sharma. And you can even independently write to him for any of the queries. And any parting words, Mr. Sharma, before we sign off from here?
Parting word is yes, India is a diverse nation. Reservation is as old as India itself. Reservation is required. Reservation is required because there was discrimination. But once there is a level playing field, that is once everyone is equal, you cannot treat equals and unequals again. That is, you cannot treat someone who is equal and unequal and give them reservation in super specialty courses. This is what I am dealing with, super specialty courses. But yes, reservation is required, as in the India we know how it is. And merit too.
Great. So it was a pleasure being part of this segment, and stay tuned.
Thanks for having me, Jay.
Anytime.
It was a pleasure.
We hope to see you again for another segment.
Oh, sure.
Great. So stay tuned. Next episode is on its way. Stay home, stay indoors. Please be safe. Venture out only when it's essential. And when you venture out, mask up. So thank you so much, Mr. Kushagra Sharma, once again. Thank you all. And we'll see you very soon. So take care, and it's goodbye for now. Thank you.